There is ongoing debate within Canada about whether provinces should be making use of the Notwithstanding Clause to override judicial decisions. Is it really the nuclear option, or is it reasonable to use it? Joining us today from Saskatchewan is Bronwyn Eyre. She is a senior fellow with the Aristotle Foundation for Public Policy, Saskatchewan's former Minister of Justice, and the author of the new report, Parliamentary Sovereignty is Not a Nuclear Option. Great to have you with us today, Bronwyn. Welcome.
Lovely to be here. Thank you.
Thank you. Okay, so you use the term nuclear option there in your title. It brings to mind, obviously, the finality of something or overriding power. Can you briefly explain?
Well, I think it really depends whom you ask when it comes to the Notwithstanding Clause. It all depends on perspective, right? So it's either, the nuclear option or a fundamental constitutional counter against judicial autocracy, judicial activism, charter activism, and very important to democracy in Canada. So that was really the point of the report and the reality check from the Aristotle Foundation, to look at the Notwithstanding Clause in its real historic context in Canada.
Mm-hmm. There are many Canadians who are expressing concern over judicial overreach. And as a lawyer and a former politician, when did you see this overreach start to happen? And do you think that it will continue to happen?
Well, it's been coming on for a while, and many trace it to the Charter of Rights and Freedoms, 1982, and the slow evolution of more judicial activism, more judicial overreach, many would think, into political decisions. But what's important about the Notwithstanding Clause and to remember about it is that it is a fundamental part of the Charter of Rights and Freedoms. And the two of the key founding fathers, if you like, of the Charter, former Progressive Conservative Premier of Alberta, Peter Lougheed, and former NDP Premier and constitutional lawyer Alan Blakeney, also a former Attorney General in Saskatchewan, were very, very intent on the importance of the Notwithstanding Clause in the Charter. And I think people forget that. And one of the things that I point out in the report, the reality check with the Aristotle Foundation, is to remember their actual quotes and what they actually said about the importance of the Notwithstanding Clause. So Peter Lougheed, to quote him, he said that we needed to have the supremacy of the legislature over the courts. We didn't want public policy to be dictated or determined by non-elected people. That was Peter Lougheed in 1982. And Alan Blakeney said that the clause was intended to ensure that the state could, for economic or social purposes or reasons, or because other rights were found to be more important, choose to override the Charter. So that's key. When provinces use the Notwithstanding Clause, they are overriding certain Charter rights. But founders of the actual Charter believed that the Notwithstanding Clause was a very important democratic tool. And I think what we're seeing with judicial overreach is the use of the Charter for very political policy purposes. And that's when people start to get a bit nervous.
Mm-hmm. Can you maybe give us a couple of examples of how the Charter is being used to prevent provincial or municipal governments from enacting legislation to do what the public sees as common sense action?
Right. So, for example, the Section 7 of the Charter, life, liberty, and security of the person, is increasingly being used in areas which I think many people would agree are strictly in the policy realm. Bike lanes, for example. The establishment of bike lanes in Ontario became a life, liberty, and security of the person issue, according to the courts. And there were orders to dismantle bike lanes based on that charter section. Similarly, with homeless encampments, a famous example in Waterloo, also in Ontario, where a court weighed in and said, until every unhoused person in that encampment can be found somewhere to live by the state, by the municipality, life, liberty, and security of the person is such that you can't take down the homeless encampment, and so on, right? You have child activists, environmental activists in Ontario who are taking on the entire climate change plan of the province of Ontario based on life, liberty, and security of the person, and are being allowed to continue that litigation based on that section. So I think when provinces start to balk at that and say, what about our ability to actually pass policy and pass legislation, it's really getting to be a sign of desperation that provinces have to use the Notwithstanding Clause to actually do that and make policy, pass legislation for the electorate who can vote them out.
Yeah. For those who see the use of the Notwithstanding Clause as a nuclear option, what exactly is it that concerns them? Why is it seen as an extreme response?
Well, I think that they would say, and it's come to be the belief that the Notwithstanding Clause is some kind of emergency safety valve that you release and should only be used, I've heard commentators say, in non-controversial circumstances. Again, that's all really in the eye of the beholder, isn't it? And so it gets into, what, when and how depends on your point of view on these things. I think that there is concern about provinces using the Notwithstanding Clause, which, as I say, some perceive as a nuclear option to override, the courts weighing in, depending on how you see that. And again, others would see it as a very important democratic right that provincial legislatures have. What I would point out to those people, and again, I think it's important to be reminded of this, that Quebec, after the charter came in 1982, between 1982 and 1985, Quebec, the province of Quebec, notwithstood everything. They notwithstood every single piece of federal legislation between 82 and 85, and have since that time used the Notwithstanding Clause far more than any other province. So if you are slightly cynical about these things, you could say that people have become alarmed about the use of the Notwithstanding Clause. And by people, I mean not only pundits and critics, but also the federal government. You could say that they are particularly attuned to this issue now that small c conservative provinces have begun to use the Notwithstanding Clause, Ontario, Alberta, Saskatchewan, and are therefore now weighing in and saying that repeated use, as they're calling it, of the Notwithstanding Clause should not be allowed, which is ironic given how repeatedly Quebec used the Notwithstanding Clause.
Right. And if the province of Quebec notwithstood every single piece of federal legislation between 82 and 85, why wasn't there an uproar back then?
And that is the question. And it's a very good one. And now the Notwithstanding Clause is before the Supreme Court of Canada. Ironic, because the Notwithstanding Clause was supposed to be a guard against judicial overreach, and it's now being decided on at the Supreme Court. Who knows what they will come back with? They're currently deliberating on it, and are they actually going to pass judgment on and weigh in on controlling the Notwithstanding Clause? That is going to be a very serious constitutional reality if that is indeed the case.
Yeah, and if you mentioned that the Supreme Court of Canada looking at a proposal from the federal governments that courts should be able to issue declarations even after the Notwithstanding Clause has been invoked. So wouldn't that be somewhat like amending the charter, which would need all the provinces to be in agreement?
Well, it's very complex legal territory and constitutional legal territory, and it's an excellent question. What basically is before the Supreme Court is the ability of a court to, even once the Notwithstanding Clause has been invoked by a provincial legislature, let's say, what's before the Supreme Court is whether a court can then still weigh in on the constitutionality of that issue. And there are two sides to that, as there often are, certainly legally. And the one side is that once a legislature invokes the Notwithstanding Clause, that's the end of the road. Courts cannot weigh in. They can't talk about, well, even if the notwithstanding clause had not been invoked, this is how we feel about it. That's a very serious issue. It's the preemptive use of the notwithstanding clause and whether courts can still weigh in once that occurs. And many feel very passionately about the fact that they can't. So we'll see what the Supreme Court says about that.
Yeah, what are the odds of the Supreme Court of Canada siding with the federal government's proposal on the notwithstanding clause? Would they be hesitant because of a huge backlash that they could get from Quebec, not to mention Alberta?
Well, I hate to say it, but if I were a betting man, I would say they're going to weigh with the federal government. But I that's being a little bit cynical on my part. I hope that's not the case. I hope it doesn't become about, these provinces using it where it's been used so many times by Quebec. And it is interesting to point out that the case that's currently before the Supreme Court involves Quebec. It's the Hack case, HAK. And in fact, the Quebec Court of Appeal said, no, you have the right as a province to preemptively invoke the notwithstanding clause and courts can't weigh in. So that's what's being appealed. And we'll see what happens, whether the court agrees with Quebec or not. And again, I hate to be cynical about it, but I think if it were Alberta or Saskatchewan, it might be a different outcome. If it's Quebec, generally Quebec is successful in these things. They push the envelope and people pay more attention to that constitutionally down east. So let's see where it goes.
And by the way, Bronwyn, do you have any thoughts on Prime Minister Carney's recent appointment of Manitoba Judge Glenn Joyal in the Supreme Court? I guess he's been pretty outspoken against judicial overreach, right?
Well, I think that from what I hear, Justice Joyal is a very strong, solid choice. We'll see where this all goes. I've heard good things about him, but I think that it is important as this conversation moves forward. When we look at the Supreme Court and we look at what former justices of the Supreme Court, the late Bora Laskin, for example, and 95-year-old John Major have said about political overreach, they also have been very clear. And so this conversation about when and how judges start to weigh into the political sphere, they both were very, very clear about how it should not happen, and that it really basically not weighing into the political side of things ensures judicial independence. Whereas we see the Supreme Court Justice, Chief Justice Wagner now weighing in on things such as the Freedom Convoy and not recusing himself on the Freedom Convoy appeal, that sort of thing. That starts to create issues. We'll see where, Justice Joyal comes down on these things and where he stands on this increasing issue of judicial activism. It's again, slightly ironic that Chief Justice Wagner, said very recently, just a week or so ago, that there should be that there should not really, in effect, be criticism of the Supreme Court, of courts, because that starts to blur the lines between the political realm and the judicial realm, where he himself weighed in on the political side. So you can't have it both ways.
There you go. Exactly. Thanks so much for sharing your expertise with us today, Bronwyn. Appreciate having you on.
My pleasure. Talk to you again.
Bronwyn Eyre is a senior fellow with the Aristotle Foundation for Public Policy, Saskatchewan's former Minister of Justice, and the author of the new report, Parliamentary Sovereignty is Not a Nuclear Option. I'm Jeanette Roche on behalf of all of us here at Bridge City News. Thanks so much for watching.